Hello all, welcome to another session on copyright laws. In today's session, we will understand when and what amounts to infringement of copyright in detail. Then we'll understand what are the types of infringement. Then we'll further go into the test for determining infringement. And the last topic of today's discussion would be acts which do not amount to infringement. So let's start. What is infringement? It is discussed under section 51 to 53A of the Copyright Act. So what amounts to infringement of a copyright? Infringement is primarily when somebody else uses the original work of the copyright owner without his prior permission. So if I am the owner of a copyright work, then that particular work is to be used only by me. I have the rights over that particular work and I have all the rights regarding that work and how am I supposed to use that work. So if anybody else uses that work without my permission, then that will amount to infringement of copyright. So infringement is primarily when somebody else uses the original work of the copyright owner without his prior permission and makes benefit out of the same. He might gain some he might circulate it in the market if it is a literary work and then may gain some profitable benefits. So that is what infringement is. So in order to use somebody else's work, that is somebody else's copyright protected work, license or assignment by the author, that is the owner of the copyright, is mandatory. Without that, without permission from the author, which may be in the lines of in terms of license or assignment, if that is done by somebody, then that amounts to infringement. So copyright in a work is deemed to be infringed when any person without a license that is granted by the owner of the copyright does anything which is the exclusive right of the owner of the copyright, which is guaranteed by the Act, by the Copyright Act. And this was stated in Fateh Singh Mehta's versus O.P. Singhal. So if I am taking somebody else's work without his permission, he has not licensed me to use that work, then whatever the thing I am doing with that particular copyright protected work would be infringement. Now in order to find out so what is infringement, it is not necessary that the the original work is exactly copied in the copy that I am circulating. So it is mentioned, it is not necessary that the alleged infringement should be exact copy of the original work. It is not necessary that it should be exact copy, but what is necessary? It is necessary that the essence of the original copyright protected work should be copied, and the essence should be copied in the infringing work. So if it is a literary work, let's say, then the theme, the narration, if it's a story, then the narration, the way it is narrated in the original book, it is narrated in the same way in the infringing book. Also the name of the characters, it is also the name of the characters as well, and whatever the dates, the timeline, so the theme, the characterization and the narration, this amounts to the essence of the copyright, essence of any book or any original copyright protected work. So if the essence of the original copyright protected work is copied, then it is said to be the copy of an original work, and a substantial resemblance must be there between the infringing copy and the original copy. So that would amount to infringement of a copyright, and a mere resemblance of some places or some dates or can be coincidence, and it would not amount to infringement. So this substantial resemblance is necessary to say that the infringement has been done, was stated in the case of R.G. Anand versus Deluxe Films. So this is infringement when you copy somebody else's work without his prior permission and you infringe the rights of the owner, which is guaranteed under Copyright Act, is infringement of a copyright. Now let us understand what are the types of infringement. So there are basically two types of infringement. The first is primary infringement and the second one is secondary infringement. Now primary infringement, it is stated under section 51A subclause A, and secondary infringement, it is stated under section 51A subclause 2. Now in basic one line, we can understand what is primary infringement. It is a direct infringement by a person and an organization. So there is an original copyright protected work. I copy that particular work and circulate it and make profits out of it. That is primary infringement. Now what is secondary infringement? When I take a copyright protected work and I do not infringe it, I ask somebody else to make copies of it, or I influence somebody else to copy this particular copyright protected work and then use and then circulate it in the market and make profits out of the same, that would be secondary infringement. So when somebody facilitates another person to infringe upon copyright, this is secondary infringement. We'll understand now these in detail. Let us first understand what is primary infringement. So primary infringement is when direct infringement by a person or any organization is done of an exclusive right. An exclusive right is given by the Copyright Act. That is the primary infringement is read with section 17 of the Copyright Act. Section 17 is the first owner of the copyright. So author of any particular copyright work is the first owner of the copyright, and it is stated under section 17. So primary infringement is when you infringe or when you do something which is against section 17 of the Copyright Act. So it is the direct infringement which is done by a person or an organization, and when the defendants without prior permission reproduces or produces the copyright's owner work, and it is mentioned infringement of rights of first owner of the copyright, which is under section 17, which is as per section 17 of the Act. So direct infringement is what primary infringement is all about. Now copyright holder will use circumstantial evidence to prove that exclusive right which was guaranteed by the Act has been violated here, and copyright holder will also need to show that the defendants had some access over this particular work. That it may be a case that I am the author of a book and I have some assistant PA. So he would obviously have access over my work since he works under me, and then after some day he later on he copies my book and circulates it. So the connection, so the access, so I will be able to prove that the person was able to access my work and they are similar. That is why primary infringement would have to be committed by the person. Now what is secondary infringement? It is when a person facilitates another person to infringe upon copyright, then it is known as secondary infringement. So I do not infringe the copyright's owner's right on my own, but I influence somebody else to do the same. That is secondary infringement. Now the court here will look into the secondary infringement in two different types. The first would be contributory negligence, and the second would be the contributory liability, and the second would be vicarious liability. Now what is contributory liability? It is when the superior party must gain some financial benefits out of the same. So if I am influencing somebody to do anything which is wrong, anything which is infringing the copyright of somebody else, then I must gain some monetary benefits out of the same. That would be contributory liability. And for that contributory liability, and we also call it contributory negligence, the financial link has to be established between the facilitator and the infringing activity. So the contributory liability, this is it. And now the court to find out whether there was a vicarious liability. Now what is vicarious liability? It is when the person accused must have directly induced infringement by others or provide means to infringe with having knowledge of the infringement. So in vicarious negligence, what is important? Knowledge of infringing activity is necessary. So in secondary infringement, there are two ways to find out what was how the infringement has been done. The first is contributory negligence by the method of contributory negligence, and the second would be by the method of vicarious negligence. Now, in order to establish that the secondary infringement has been done by a way of contributory negligence, I will repeat, secondary infringement has been done by the way of contributory negligence. It will be proved only when a financial link will be established between the facilitator and the infringing activity. And a vicarious negligence and secondary infringement has been done by way of vicarious negligence. In order to prove this, the knowledge of the infringing activity is important, is mandatory. So this is secondary infringement. So these were the two types: primary infringement and secondary infringement. Now let's move to another slide here. Sorry. Now we understood what is infringement, we understood what are the types of infringement. Now what are the tests to determine that whether infringement has actually taken place? The test to determine whether primary infringement has taken place or whether secondary infringement has taken place or whether infringement at all has taken place. So these are the two tests which the court or which any person applies to find out whether there has been infringement of any particular copyright protected work. The first is substantial reproduction test and the second is layman observer test. So these are the two tests which we apply to find out whether the infringement has been done. So the first, let's understand what is substantial reproduction test. There are two things which is very necessary, which is how we apply substantial reproduction test. The first is whether substantial portion of the original work has been copied, and the second, whether the essence of the original work is copied in the infringing work. So if the substantial portion, major portion of any copyright protected work is copied and it is produced and reproduced in the infringing work, then it would be held that the substantial reproduction test would apply here, and the infringing copy would be said that it is infringing. Now, and the second most important and the second criteria is the essence of the original work. Now by essence, any work, any copyright protected work, there is some essence to it, and if you copy the essence out of it and you destroy it, you mutilate the essence, then also it will be said that the infringing copy of the original work is will say that substantial reproduction test will apply in the infringing copy and in the subsequent copy, and it would be we would say that the subsequent work is copy of the original work. When will we say that? The first is if the subsequent work is if the portion of the subsequent work is substantially copied from the original work and the essence of the original work is copied in the subsequent work. The second is layman observer test. Now what do we understand when we say layman observer test? Whether the mere idea was copied or the whole work was copied is to be seen and determined by a layman, that is a person with reasonable intelligence. Now let's say there are two work, the one original and one alleged infringing copy. Now in layman observer test, what happens? I put the copy in front of my in front of my eyes, and I see to it that after reading it, or after merely if it's an artistic work, then by just seeing it or properly investigating it. If it is a literary work, then by reading both the works, I will find out that whether whether the basic idea of the original work is just copied. Then if the idea is copied, then we know that idea is never given a protection. Expression of an idea is given protection, so then the subsequent work would not be held as an infringing work. But if the whole work is copied and it is presented in presented in different word, different language, but the whole work is copied as it is, then it would be said that the layman observer test would be applied here, and it would be said that the subsequent work is a copied work. And now who applies this work? This test is done from the perspective of a person considered with a reasonable intelligence, and not by, say, some scientist or some person with some extra intelligent person, but a person with reasonable intelligence is said to this test is done keeping in mind of a person with reasonable intelligence. So there is a case, Ram Sampath versus Rajesh Roshan. Ram Sampath versus Rajesh Roshan. Here the music of Crazy 4 song, the first 60 seconds of the song was copied. There was a song in Crazy 4, and the first 60 seconds of that particular song was copied from a song or a music piece that was composed by Ram Sampath. He is a music director. So when he heard that particular song of Crazy 4, he fought for his rights, and then applying the layman test, it was said that both the songs, the first 60 seconds of the song is an exact copy of the music piece that Ram Sampath has created, and just by listening to both the sound recordings, it was held that the subsequent song, that is the Crazy 4 song, is an infringing work, and it was held that the infringement has been done by the music director of that particular movie. So this is layman observer test. So these are the two tests: substantial reproduction test and layman observer test. Now let us understand. We understood what is infringement and what are the tests to determine whether the infringement has been done or not. But there is exception. There is always some exception to any rules. So what are the exceptions? So in copyright as well, there are some exceptions, as in, even if you do not have prior permission by the way of license or assignment from the original author, from the owner of the copyright, then also if you do certain acts, it will not amount to infringement. So acts which do not amount to copyright infringement, there are certain acts and they are recognized by the Copyright Act. So what is the main purpose of recognizing these exceptions? It is merely to enable the reproduction of the work for public purpose, and the copyright protection, although it guarantees the right of the owner of the copyright, but it should not constrain the free flow of knowledge. So if I use the particular copyright protected work for private study or for research purpose or for public benefit, then these are the certain, this act would, although I would not have the permission from the author or owner of the copyright, then also my act would not amount to copyright infringement. So section 52 of the Copyright Act clearly states that there are certain acts which do not amount to copyright infringement. The first is it's a very elaborate section. I have shortened it and written down some of the major important points. The first is when fair dealing of any work. So if I do it, if there's an original literary work and I copy that particular work and I use it for my research purpose, and I use it in my to study it or to help others understand it. So I have been doing I have been fairly dealing with that particular original copyright protected work, and I did not gain any monetary benefits out of the same, then it would be fair dealing. Then that particular act would not amount to infringement. Or reproduction of any work for the purpose of judicial proceeding, then that also would not amount to infringement of copyright. Also, if any work which is prepared by a legislature and I reproduce that particular work, it would not amount to infringement if at all the legislature has not asked to publish the same, then it would amount to infringement. So the reproduction or publication of any work which is prepared by legislature would not amount to infringement only when the legislature has particularly not asked to do the same. And we discussed this, the reproduction of any work by a teacher or a pupil in the course of instruction. So if I'm teaching you something and I search online, I found a material, I found it interesting, I found it intriguing, I copy the same example, I copy the same narration and I dictate it to you and I make you understand it, then it would not amount to infringement, because here I am explaining it is for study purpose, it is for research purpose, it is for public benefit. So it is in the course of instruction, it would not amount to infringement. Although I do not have the permission to do so, I did not ask permission to use that particular book, that particular narration which I found online, but I can do so because I am fairly dealing with it. Also, I can make copies of a book from a non-commercial public library, not more than three copies of a book which is not available in India. So if there is a book on say physics which is very relevant, which is very properly written, and I want that particular book, if it is available in any public in any library, then I can copy the book. Not more than 3 copies can be made. If I make a 4th copy, then that would be infringement. So not more than 3 copies can be made by me. It would be considered as an act which is not infringing. Now the performance of a literary or dramatic or any musical work, if the performance is done to a non-paying audience. So I take a book, it's a literary work, so I take any literary work, I dramatize it and I present it in front of a non-paying audience, then also it would not amount to any infringement. The third, the reproduction for the purpose of research or private study, or if judgments that the court produces, so any judgment or order of the court, tribunal or any judicial authority which should not be prohibited from publication by the respective court, then if it is not prohibited from publication and I publish and I reproduce those judgments from the different courts or tribunals, then that also would not be held to be infringing. And there are many such things. You can please go ahead and read section 52 of the Copyright Act, you will understand. And the last one that I have written is production or publication of a translation of acts or legislature or rules. So if there is an act of a legislature, or if the legislature has made some rules or acts, so I can translate the same and I can publish it, and that won't amount to infringement. So this was today's session. We discussed infringement in detail today. What is infringement? What are the types of infringement? Primary and secondary infringement. Then we discussed the test which is used to determine whether the infringement has actually been done or not. There were 2 tests: substantial reproduction test, and the second was layman observer test. Then we discussed some exceptions to infringement, that acts which do not amount to copyright infringement, although the acts have been done without prior permission of the author, but then also it would not amount to infringement. And section 52 of the Copyright Act clearly talks about what are the acts which do not amount to copyright infringement. So with this I conclude today's session. Please raise any doubts if you have, and thank you very much. Have a nice day.